An application for summary judgment is us saying to the judge, we know justice must be seen to be done, but we don't want this to go to trial. Do you want to elaborate on what an application for summary judgment is and why it is used and what circumstances you would recommend it?
I don't know whether I would recommend it. So I'll start with I think nine times out of 10 I wouldn't.
Okay.
Now, summary judgment is a way of either the claimant or the defendant stopping the case and saying, look, if you're the claimant, there's actually no defence. So instead of all the disclosure we have to do and what else do you have to do in build up to a trial? But anyway, disclosure is one of the things, getting all the witness. You stop it there and then.
No need for it to go to trial.
Yeah.
The whole point of justice.
Because building up to a trial takes ages. I mean, there's an awful lot to do. So summary judgment is about either the claimant or the defendant stopping it, hopefully at an early stage. So the test is whether the claimant or the defendant has a real prospect of success. Now, if you're the claimant,
similar to
setting aside the judgment, if there's cracks others.
Yeah.
So what is a real prospect of success? Now, in my view, if you're the claimant saying that the defendant hasn't got a real prospect of success, it has to be 99.999% watertight. Because I don't think judges like giving summary judgment, because it is stopping the defendant from having a trial, which is an age-old right, as it
justice must be seen to be done
of a citizen, of a subject.
Yeah.
So they don't like preventing the defendant from having a trial. And although it says in the White Book, somewhere in here, a real prospect of success, and gives cases on what a real prospect of success is, I think if there's any issue which is at all triable, which means needs to be discussed, each side needs to put their own, then the judge won't allow it. For example, in our case, where the judge was wrong in saying that I'm satisfied he hadn't received it, I think even if it had been the proper test of real prospects, does the defendant have a real prospect? He would have found something, because they don't like.
He would have found something.
He would have found something. But because they don't
couldn't
like
find anything, so he went.
They don't like doing it.
He went for the.
And the solicitors do it. Solicitors do it, and I wonder whether it's to get the costs, because they're on
allocated.
Even you can do summary judgment any time up until trial.
Yeah, so you do it.
But I wonder whether for small claims, as you say, solicitors don't get involved. But generally, I wonder whether solicitors shouldn't be doing it, but they think they'll give it a go, because what have they got to lose?
Yeah, because
they'll get the costs. I mean, it's nice to be a 15 grand out application.
Yeah, they get their costs.
But I don't think judges like it. In fact, I've in my 12, 13 years at the bar, I've never. This might say more about me as my quality of being a barrister. Putting that to one side, I've never had a successful summary.
Well, we did.
Yes, we did.
We did. But having said that, that was because, a very, very interesting story. You was just about to go into the hearing.
Yeah.
For the application to be heard. I was pretty convinced that we're going to get this. You've always erred on the side of caution, typical barrister. Not the most optimistic or enthusiastic.
And I think it's Scottish. That's really embarrassing.
I thought, we're going to get this. We're going to get this. You were just about to go into court, and I got a phone call from the defendant. Literally minutes before the application was due to be heard, he'd been involved in a road traffic accident, and he said, "How much do I have to pay?" He'd given in. Yeah. He'd given in even before. Yeah. He'd given in before the summary judgment application could have been heard. I didn't get on the phone to you. I said, "Hey, look, he's paid."
You got everything. Yes, I remember.
I got everything. So you just went before the judge.
That's right.
And you said, "Look, it's been settled."
Yeah. Yeah, I like things like that. Hurrah!
That could be your. Does that qualify as a win on a summary judgment application?
It does.
Having said that, he had a road traffic accident. Come on, Do you? Oh,
No,
I think he cracked, to be honest.
Yeah.
But
So many people do, and this is the other thing.
And again, that goes back to your point, what you said earlier. You think people, solicitors and legal representatives, as was I in that case, use it as some kind of strategy to get the other side to crack without.
No, I think maybe they do, but I think more often they think they've got nothing to lose. If you're a solicitor, well, let's give it a go for summary judgment. If you lose, you get your costs.
When we wouldn't usually get it at trial.
Yeah, I think a summary judgment may be very early on. Maybe 2 weeks. 2 weeks after, if you've seen the defence and there is no defence at all, maybe you could get summary judgment.
On the flip side, we had one case where we went for summary judgment because I was absolutely confident that I've got a telephone transcript where in a recorded conversation, the defendant knew it was a recorded conversation because that was what greeted him when he phoned me, and he admitted to paying £2,500. Okay, fine, didn't pay it. I'll just put a shorthand particulars of claim. Don't need to put longhand particulars of claim, just shorthand money claims online, £2,500. I've got evidence that he's admitted to it in a telephone transcript. We'll go for summary judgment. And any layman looking at that would think, yeah, you got a cast iron case.
Yeah.
You got a telephone transcript. He's admitted in a telephone conversation that he's going to settle at £2,500 of what was a £6,500 claim. Settle at £2,500. Admitted that he'd pay it, but didn't. We got a cast iron case. But even so, the judge threw it out.
He didn't throw it out. Well, he did.
Well, kind of.
He dismissed the application. I suppose it's the same thing.
Against all that evidence, but
there is. You see, again, it goes back to my point that if there's any unsurety at all, they will go for trial. Now, in this case, you say, an interview, and I suppose it's a bit like a police interview.
Yeah.
What were the precautions taken? Because the defendant said, well, hang on, he was a debt collector. I felt pressurised. I just thought I'd say anything, and of course the judge has to accept that because he doesn't know the circumstances of the court, even though it was plain. And I think there were one or two phrases from memory used which could be interpreted either towards our detriment.
But at the same time, the point he made was there was me thinking, oh, just do shorthand. I don't need to go for a laborious longhand particular claim. And the judge made the point. Yes, you might have the evidence, which is thin in his opinion.
Yes.
But nevertheless, you need to spell it out in a particular claim.
Yes.
That it was a settlement.
Yeah.
But even so, thanks to your representation, you encouraged the judge to make an order.
Yes.
Giving us time to amend the particulars of the claim.
Yeah.
Invite them to defend it.
Yes.
And the funny thing about this case is, whilst he criticised me for being a bit of a bully in the telephone transcript, what the judge then did is exactly what I did, which was, hey, look, if you don't agree to £2,500, we will issue a claim for £6,500. And I remember the judge actually said, well, it could be more.
Yes. Yeah, absolutely. He gave a very good order to the effect that we particularise the case, which meant that it could either be for more money or less money. So I think on the whole, judges know exactly what's going on.
And we particularise the case for a lot more money, and that was the whole point of the settlement for the 2.5, which he defended.
Yes.
He was better off.
He would have been better off taking it, accepting that,
but
rather than having.
But he tried to be smart. He tried to be smart.
Yeah.
And the judge gave our client the opportunity to re-particularise the claim, and we ended up, cut long story short, getting judgment for including court fees and interest for about £8,000. It was a pleasure having you in today, Robert.
Thanks.
And education, some fantastic information you've shared with our viewers. If there's anything in this interview of interest to you, please do get in touch. Our telephone number will appear at the end of the video. Remember, please like, comment and subscribe.